Foley, and today I'm going to about an old case of mine. Several years ago, I got called in on a case. It was a very serious case. It was armed burglary. It was aggravated stalking, letters of intent to kill, and aggravated assault. Very serious case. The gentleman I was presenting was facing life in prison, and it was just a very difficult case. So I'm going to tell you about some of the facts of the case. I'm not going to tell you any identities. I'm not going to tell you where it was. I practice all over the state of Florida. Um, so I'm going to walk you through what I think was just a very intriguing case. So police are ultimately called uh, by an individual saying that their ex-boyfriend sent them a text message threatening to kill them and then himself. And it was a text message, so it was easily verifiable. Um, Police show up at the residence. They go through the residence to make sure that there's no one in because the woman wasn't home. She ultimately ended up, I think, going to a hotel that evening. Um, Obviously scared, right? If someone that you love, someone that you dated, calls you up and says that they're going to kill you and then themselves, I mean, obviously a reason for concern, and this was a very serious case. Um, so I ultimately, oh, so the police show up. The woman goes and stays in a hotel for the evening and comes back. I don't know if it's the next day or the following day. Maybe 2 days had gone by. Maybe it's one day. Um, and this woman's in her home and she's washing clothes. I think her teenage son or daughter is home. She has a couple of kids, and all of a sudden, pops in the defendant. Defendant has a bag in his hand, strapped like a duffel bag or like a knapsack that you might carry for school. And he sticks his head under. Well, he basically comes into the room. I forget how he gets into the room, but he basically is in her house and says something to the effect, "Can we talk?" And of course, right, this woman is scared. I mean, extremely scared, especially considering the email from a day or two ago or the text message from a day or two ago. And at that point, she starts to back away from him, and she sees he reaches down and starts to open up a duffel bag. She believes that there's guns in there, but she doesn't wait. She runs. She goes into an area of the house. She locks the door behind her. She gets her kids, and they flee the home rapidly. Ducking behind bushes, hiding. Dials 911. Obviously, this is a serious incident. SWAT team comes, dozens and dozens of police officers, and the when the police arrive, the defendant is no longer in the house, so they're looking for him. They set up a perimeter, and obviously they're on high alert because of the statements that he has. This person, in her past, she knew him. Obviously, they dated for some length of time. He was a collector. He had prior uh, experience, background dealing with weapons and what have you. So they're on full alert. I mean, I don't know if there's helicopters, but there's a lot of police. I mean, a lot of police, and they're basically boxing off like a square mile or two to locate this person. Ultimately, they're checking the house. They're going through the yards. They're looking, and they get her. And because it's an alert, and because of the fear that the police have, as in addition to this woman and her family. Um, they actually have her next to a police car, almost like in a prone position, because they don't know if they're going to be fired upon. But there's a secure. I mean, there's police on every corner. Ultimately, an officer comes into contact with someone who meets a description to some extent because there's a bolo be on the lookout for. This person's walking down the street. Apparently, well, you find out later that took an Uber there. So an Uber to her location. So a police officer comes up to him, holding his weapon, in the prone, and says, "Stop, don't move," and identifies obviously a police officer. Says, "I don't know you, but I need you to put down the bag. I need you to put your hands up. I need you to step away from the bag," and he's detained. Of course, the defendant, like any defendant, generally doesn't go, "Oh yeah, it's me." So he calls over the police. I don't remember if he gave a fake name or not. I don't think he did. I honestly, he may have. He may have just not openly given his name right away. But ultimately, they realize that it's him. He's handcuffed without incident, and they go into the duffel bag. In the duffel bag, there are 2 or 3 weapons, lots of ammo. That's the only thing in the bag. He ultimately gets charged, right, for the armed burglary, entering the premises of another with the intent to commit what harm, right, an aggravated assault. Hey, I'm here. I'm in your house now. I haven't been invited in. We've been broken up for some time. And this gentleman is sitting in jail. His family hires me, uh, and I go in and meet with them in jail. And ultimately, I get his version of events. But ultimately, I have to come up with a defense to the case, right? He's facing life in prison. And some of you may watch this and go, geez, I hate you. Um, but me until you need me, or you hate defense, or you hate attorneys until you need one. So here I am, and I'm hired on this big case. So what happens next is I learn enough about the gentleman, and sort of what's going on in his life, because I have to as my client. There's always 2 sides to the story. So yes, this is not a good fact pattern. Obviously dangerous. Texting and emailing is going to write. He's going to kill the person and then themselves. So he's held no bond. So the case takes a while, right? It's not a quick case. We have dozens and dozens and dozens of police officers, um, and we have the family, and there's a lot to go through. So I take a lot of depositions. They're set up, and it takes several months to do it. And then ultimately I go, geez, see, the internet comes back. Okay. So obviously the client doesn't want 20 years to life or life. Um, but ultimately is not going to take a plea. So we do what we refer to as a focus group, and I got a guy who's really great. I don't want to say names because just because there's confidentiality. I'm telling facts, and um, facts that are public record, but ultimately I don't want anyone to be able to watch this video and know who this person was, or what this case was, or what jurisdiction in Florida it was, or whatever. So anyway, we go in, and I bring another in to help me, and we do some focus groups. And these focus groups help us. They're like mini trials where we give a group of potential jurors fact patterns. And we usually start off with what the state is going to present, right? The police reports, the statements of witnesses, the statements of victims. And obviously, when we present it that way, without any argument, without any cross examination, without any of the defense facts or facts that we want to get into evidence, the jurors or the mock jurors come back and they go guilty, right? Pretty simple. Um, Especially on these facts. And they get to hear 911 call. They get to hear some text messages, not hear text messages, but see text messages. But I believe that the woman even recorded some of the telephone conversations. So we were able to present that because that came to us in our discovery. Even though it's illegal to record another person, and they probably weren't going to get those tapes in because we would file motions in limine to exclude them. There were tapes, right? So it's damaging information. Obviously, something that a judge probably would suppress, but still it would be in the back of his or her mind and could obviously affect sentencing quite drastically. So we go through all of these things, and ultimately we come up with the theme of a case based on what the jurors say, because normally when you have a jury trial, you don't get to ask questions of the jurors like, hey, what was important to you, or what didn't you like, or what did you like? So we focused on the things that these mock jurors thought were important, and we narrowed, right, because the case is so big and the facts are so horrible against us. We narrow them down to facts that are true, but that help us. And ultimately, as crazy as it sounds, some of the conversations that occurred between the parties prior to, weeks prior to, months prior to, some of our jurors started to see a pattern where they thought that the woman was leading her boyfriend on, or her ex-boyfriend on, and the things that she would say, and she would engage in conversations, and she would engage in text messaging and going back and forth, back and forth. And it was weird because it was not something that I picked up on, but it was the mock jurors, and they go, hey, you know what? She's saying, I don't want to deal with you, but she's texting him at random hours. She's talking to him. She's saying this. She's amping the conversation up. And it's like this sort of dark conversation that's going on between both parties. And there was something about it that the jurors, the mock jurors, were going, hey, you know what? This just doesn't seem right. If someone's scared, if wants to break off a relationship, they break off a relationship. They don't keep talking to the person for day after day, week after week, month after month. So we started thinking, hey, you know what? Like maybe these conversations, maybe these text messages are something that we don't want to get out. Maybe we can bring a case about this person who is engaging in a back and forth conversation where they're both saying things that are dark and threatening to each other, and threatening violence to each other, and saying things that you and I would go, geez, like that's just too much information, and that's just crazy, and who acts like that? But there was a give and take. So we presented with another mock trial. I think we did 3 mock trials on it. And each time we kind of molded and adjusted. And by the end, I think we had, I don't know, it was like 100 potential jurors. And we, they would fill out documents like verdict forms, guilty, not guilty, unsure, right, to see if we'd have a hung jury. And ultimately, at the end of this long period of time, which took us about a year to prepare all this, and we were getting ready for a trial, I said, you know what? Going to present this to the prosecutor. And there were several prosecutors on the case. They had a team, I think 2 or 3 prosecutors on this case. So, the lead prosecutor, I said, hey, listen, I want to show you what I did. Now, I didn't give him everything, but I gave him some video of the mock trial, and I gave them the verdict forms that were filled out by the jurors. And ultimately, they saw a problem with their case, a case that seemed like a literally a slam dunk, and this guy's going to do life in prison, to, hey, what is Foley doing here that we need to reconsider this and look at it from a different aspect. Now, obviously, I'm not going to give him my whole case, and I'm not going to show him everything that I did, right, because I can't. But I used it as a negotiation device, because although we got, I don't know, I think about 85% of the mock jurors to say that they were either hung on the armed burglary, or either hung up or not guilty, which that's a high percentage, 85%. So ultimately, go to the prosecutor, have a sit-down meeting, and they end up changing charge from an armed burglary to a misdemeanor trespassing. Yeah, from armed burglary, 10-year minimum sentence, 10-year minimum mandatory sentence to a life sentence to a misdemeanor. However, they leave the aggravated stalking, which I believe is a third-degree felony, and they also left the aggravated assault with a deadly weapon, which is a third-degree felony. So he went from facing life to facing 11 years maximum. The client had been in custody for about a year, and he was given time served plus a year of house arrest plus 5 years of probation. Special conditions of that probation would be that he would take it's like a batterer's intervention course. It's like 26 weeks. Also psychological evaluation and follow-up treatment. And ultimately the case ended. The guy spent a year in jail, got a year on house arrest, went on probation for 5 years, got a bunch of mental health counseling and what have you. And it was a very difficult case that pled actually the day of trial. The day before the trial, I think trial was set for Tuesday. On the Monday, the prosecutor got back to us. I think we presented all the information on like a Thursday or Friday, trying to see if there was a way, because what I didn't tell you is when the jurors said they had a problem with the armed burglary, the written threats to kill, and they all got guilty. It was like 90% or 95% all guilty because, of what he wrote in the text message. And then the aggravated assault, right, basically like showing up and having a gun and starting to pull it out, they were quite confident on that. So in our mind, we were like, geez, we have a judge in a tough area, an area that's, very prison oriented, but the armed burglary, we had 85% saying not guilty or hung. So we kind of held our hat on that, but we knew that if we went to trial, we would probably lose the written threats, the aggravated assault, and the aggravated stalking. So ultimately, took a plea to the time served and the house arrest and the probation. But I guess the purpose of telling you the story is that there are things that can be done on cases. Now, I'm not here to say I condone, what the client allegedly did. I wasn't there, but I took the facts that we had in the case on both sides, and ultimately by hiring mock juries to do this trial work or these focus groups, it really lent itself to help educate us as attorneys of what the jury found important. And obviously we must have hit onto something correct, because where you had a 10-year minimum and the best offer at that point, I believe, was like, Jesus, life. I don't even think they had given us an offer. I think it was life. It might have been 25 years, something to that effect. And the client rejected it and said, no, I go to trial, chances. So we were working to come up with something. Point is I don't own domestic violence. Do I represent people that are charged with domestic violence? Yes. Are there serious cases of domestic violence? Yes. Do we need more education? Do we need to help the victims? Absolutely. But my job in this case was strictly from a defense perspective, and I needed to put together a theme, which I did. Obviously wasn't a home run. This person, spent a year in jail, spent a year on house arrest, 5 years of probation. I don't believe there was any early termination, no early term. So, 7 years of their life was occupied, and they, got mental health treatment, psychological evaluation and treatment. So never give up, folks. Even the cases that are crazy that I take on, there are ways to, I give an analogy of taking down a tree. If you have a big oak tree in the center of your yard and it's leaning, and you hire a tree company, right? The tree company doesn't come and cut the bottom of 100 oak. They trim a branch. They go up there with the chainsaw and they trim a branch off and another branch off and another branch off, and they weaken the tree, and then they take the top part of the tree, then the middle part of the tree. This way the tree doesn't fall and hit the house and the dog and the fence and the car, but they take it, they manage it, they cut, and they weaken the tree to make it manageable. That's what our jobs as defense attorneys are to do. And this, I think, is an example of something that I did during the course of my practice that makes that analogy come to pass. So, not a home run. I'm attorney Roger P. Foley. That's one of my stories. Thanks for listening. Hey, please, I always forget to say please subscribe. I watch all these YouTubers. I'm not a YouTuber, but I do this to educate the public on the law. So please subscribe, share my share my videos. Thanks.